Are you going to have to hire an attorney? Are you afraid to call an attorney? Are you unsure if you're going to get charged or how you're going to get charged? Let's answer these questions today. Welcome back to the Lacrosse Lawyer. I'm attorney Craig Steger. How are you today, Leah?
I'm well. How are you?
I'm good. Got our first real snowstorm here in the Midwest, so kind of hunker down. Kids are all excited. How about
Yeah.
you?
Yeah, I'm excited too, waking up and seeing the nice, beautiful blanket of white snow before it gets all dirty and muddy and sandy and salty from
Yeah,
driving.
our morning should be kind of a wonderland. I got the tractor and all that stuff kind of positioned, moved my lawnmower finally. Pretty confident I won't need that anymore, so I got that tucked away and covered up. So, yeah, bring on the snow.
Yeah, finally. Last year it wasn't as snowy. It was kind of a sad deal.
Yeah, if it's going to snow, might as well get enough to make it worth our while. So, attorney's fees. Let's talk about attorney's fees, because I know this is a very common question that people have, and if you've never hired an attorney, or maybe you've hired an attorney for one kind of case but not another one, you may be kind of lost and concerned and maybe even hesitant to pick up the phone and talk to an attorney or send them a message. So I wanted to kind of break that down a little bit and hopefully help people understand what to expect, what kinds of questions to ask their attorney, law firm that they're consulting with, and so hopefully that'll help answer some questions. And if people have additional questions, feel free to leave them in the comments and we'll do our best to respond, okay?
Yeah, absolutely.
So these are not the only three ways, but I would say there's three main types of attorney compensation structures. That would be hourly, flat fee, and contingency. And I would say hourly and contingency are the most common. The flat fee is, I would say, a little bit of a newer thing. I've never actually, very seldom have I used a flat fee structure myself, and I'll explain that why in a moment. But hourly is kind of the traditional model for everything but, let's say, car accidents and work injuries. Personal injury type cases, I think for a long time, have been done on a contingency fee basis. And then flat fee, like I said, I think is becoming more and more popular. It's something I'm looking into as well, because I think there are a lot of benefits and advantages to a flat fee structure, both from the standpoint of the law firm as well as the client. So does that make sense?
Yeah, absolutely.
So let's start with the old hourly model. It's kind of the one that any of us have been practicing for a while, kind of grew up with. One of the first things that when I passed the bar exam and started practicing as a lawyer, you got this sheet with all these little lines on it, and you were supposed to record all your time in 6-minute increments, of so-called point one. So that is a model that a lot of lawyers still use, and a lot of types of cases still use. I would say like insurance defense is maybe the most common type that still uses that hourly model, where the attorney as well as paralegals also may bill on an hourly rate at a reduced amount. But it is on the old sort of idea that the best way to compensate an attorney is based on their time. Now that model I think is becoming less and less common, I think for good reason. But it is, in many ways, it's the easiest one to do for everything other than injury cases. But it's not really, I would say, the most fair or the most economical and efficient way to do it. So hourly is something that, if you would say, is still pretty common in things like divorce matters, is probably the most common in general litigation. And essentially, the attorney does their work, or the staff does their work, and then you'll get a bill every month, however often they bill for however many hours that person has worked, and at their hourly rate. And probably the biggest, I guess, distinguishing factor between different hourly rate models, besides the amount of the rate, is it going to be paired with what we would call an advanced fee? So is the person going to have to pay some of that money in advance? And that goes into something called a trust account. We'll talk about trust accounts here in a little bit. Or is it simply, I'm going to do the work, send you a bill, and then you pay? I grew up being sort of taught to get some money up front, because there's just much easier to get the money before you do the work than after you do the work, is kind of I guess the philosophy there, and it makes sense. That money, let's say someone gets, we used to call them retainers. They're actually not really retainers. A retainer is a really old-fashioned thing that I don't think gets used much anymore. You actually pay a lawyer just for the privilege of having them as your lawyer, and then they charge you for the actual work they do. But I kind of grew up calling advance fees retainers when they're not really. But it's just, essentially the idea is like you pay in a certain amount of money in advance, it goes into account, and then you just kind of work off of that each month until you run out, or if the work is done and there's still money left over, then that gets returned to the client. That's kind of how advanced fees work on an hourly structure. Okay.
So it's like a credit, kind of. So then you,
Yep.
okay. But civil litigation, which is what you mostly do, doesn't work that way.
It does for anything other than injury cases. Okay. So I do a lot of litigation that, let's say, real estate litigation, business litigation, fights over contracts. That's all civil litigation, but there's not an injury involved. Those are still typically done on an hourly basis, although I'm seeing people, myself included, trying to transition that to a little more of a flat fee model. So let's talk a little bit about flat fees, so a flat fee is, as the name indicates, sort of you're charged up front, or you're quoted up front what it's going to cost, and that's the amount that you pay. And depending on how the flat fee is set up, the whole amount might be paid at the beginning, or it may be done in installments, but the cost of the work is sort of predictable, with maybe some built-in provisions for things that happen that are unexpected. But flat fees are probably most common, I would say, in transactional type work. And what do I mean by transactional? So wills and estates, business formation, corporations, LLCs, things of that nature. Flat fees tend to work where it's pretty predictable what the work is going to be. Maybe it's a common set of documents, or if you create LLCs for people, you have kind of your standard set of documents. It takes X amount of time to meet with the client and get things ready. So once you can sort of standardize the process and predict what the work is going to involve, then that's kind of where flat fees tend to come in, because then it's just everyone understands ahead of time what it's going to cost. Is becoming more common for criminal defense and, let's say, OWI type stuff to be done on a flat fee basis. I think that's driven a little more because of the predictability of, or just so that the clients understand how much they're going to get charged, as more so than, let's say, the predictability of how those cases are going to go, because not every case is the same. The evidence at issue, the number of witnesses, all that changes, which has always been the biggest difficulty in trying to move away from an hourly model on most non-injury civil litigation, because no two cases are the same. And when you have lawsuits, you have court fights, there are certain things that I can control, but there's a lot of things that I can't control. I can't control the other party. I can't control which lawyer they hire. Some lawyers are much more litigious than others. I can't necessarily control the judge that we have, or how many witnesses there may be. That's the reason why flat fees have always been sort of difficult in most civil litigation cases, because you just don't know how this is going to play out. Although I think we're getting a little more, it's getting easier to predict. The more you niche down and do certain types of cases, the better it is, the easier it is for you to kind of like predict, okay, this is kind of roughly what I think it'll take. And you're seeing it broken down into stages. So you may have a flat fee for, let's say, I will represent you for all negotiations, a demand letter, all discussions prior to the filing of a lawsuit. So there'll be a flat fee for that amount. And then, let's say, once we start a lawsuit, up until, let's say, 6 months before trial, this is what that flat fee is going to be. Trial is always the wild card, because trials are just extremely time consuming, unpredictable, demanding, but most of them don't happen, right? And so you don't necessarily want to pay an attorney for the cost of going to trial at the beginning, when the likelihood is they're not going to have a trial. So fees tend to get kind of, in civil litigation, is tending to get broken down by common stages. But even then, it can be difficult in even before trial because, let's say you have a civil litigation case and the other side hires two experts and they're on the West Coast. And so now I got to decide, am I going to travel to California? Obviously it's much more expensive for me to go to California and take witness testimony than it is if they're across the border in Minnesota. So that is always sort of the inherent challenge of doing anything other than an hourly model for injury litigation or for non-injury litigation.
So if the experts were out of state or far away, would that be an additional charge if you were doing a flat fee model for those steps of the civil litigation process?
Yeah, you'd probably have to build in some contingencies for that. Some of that has been alleviated a little bit because it's becoming much more common and normal to conduct depositions remotely by Zoom. And so then it becomes much easier to predict and anticipate how much time and work and cost it's going to be, because you can say, well, I know I'm going to have 4 depositions, but they're normally 2 to 3 hours each. I know the court reporter typically costs this. I know the videographer typically costs this. And so that has made it much easier now that we're doing so much of this stuff remotely. So I think that's helping a little. So that I think I'm really excited about the prospects of flat fee work in litigation, in more litigation type cases, whether it's divorce, criminal defense, or just non-injury civil disputes, property disputes, contract disputes, because it can be difficult, especially in smaller communities, to even find attorneys that will do the work or do it at a rate that you can afford. I turn down a lot of work because it's going to be cost prohibitive for the client or time prohibitive for me. Whereas I think the flat fee models are going to hopefully alleviate some of those. So that's one of the things I've been working on for quite a while, is trying to figure out what's a fair way to be able to do this necessary work, this much needed work on a model other than contingency and hourly. So that's kind of the flat fee and the hourly. So let's talk a little bit about contingency fee cases, which is what most of my work is, because I tend to represent mostly injured people in car accidents, semi-accidents, farm accidents, things like that. Pretty much any of your billboard attorneys are going to be on a contingency fee basis, okay? Auto accident, car accident, slip and fall, workers' lawyers, with, I would say, almost no exceptions, but maybe very, very few exceptions, are going to be on a contingency fee basis, which means the attorney doesn't charge you up front, and the attorney gets paid based on a percentage of whatever is recovered, if there's a recovery. If there's no recovery, your attorney doesn't get paid for their time. And if there is a recovery, they are compensated based on a gross percentage of whatever's recovered, typically in that 1/3 range, maybe a little less for some cases, maybe a little more for other cases. Workers' comp tends to be, at least in Wisconsin, is a percentage that's set by statute. So you have to do the statutory percentage for workers' comp. There are also some other types of cases, med mal, for example, that has statutes that regulate the amount of percentage that an attorney can charge. But generally speaking, it's kind of up to the lawyer and the client, and 1/3 is pretty common. Sometimes there is a structured element to it, so that, let's say, it might be 1% if the case settles before filing a lawsuit. It might be a little higher percentage once a lawsuit is filed, and then a higher percentage if the case goes to trial, or maybe even another one if there's an appeal. So that is a very, very common model. One thing I will tell people about that is, if you've been injured, especially if you've been injured, you can call attorneys and you're going to get a free consultation. And I think I would say that's basically true for everyone, unless you're told. So if you call an attorney, you should not expect to get charged unless they very clearly tell you there's going to be a charge for this, or we only do paid consultation. So you shouldn't have to worry about calling an attorney and then getting a surprise bill in the mail. That should not happen. You should know in advance before you start talking to them if there's going to be a charge. And most lawyers, most law firms will do a free consultation of some sort. So contingencies, a couple other things I want to add about it, just because it is, if you've never been in a car accident before and had to hire an attorney like that, or if you've only ever worked on an hourly basis, it may be a little confusing to you. Probably one of the biggest things that you need to know when you're hiring an attorney is how case expenses or costs are handled. So there are different ways that different attorneys handle this. So the contingency generally covers the attorney's time. What that contingency typically doesn't cover is case expenses. So what do I mean by that? There are regularly going to be case expenses incurred advanced by the lawyer or law firm, such as filing fees with the court system, cost to pay the sheriff to serve the other parties, medical records. If you request medical records, there's usually copying charges from the hospitals. As I mentioned earlier, if there's depositions taken, there will be a payment made to the court reporter for their time. Those are things that we call case expenses. Hiring experts is often a case expense. And so one thing that's important to know is first of all, if there's a recovery, does the 1/3 include those case expenses, or are those case expenses in addition? Typically they're in addition. So let's say the attorney's fee is 1/3, they take 1/3 of the gross fees, then out of the 2/3 remaining, they get reimbursed for their case expenses, and then from there it goes to the client. If it's included, that's a good deal, but it's something you want to know. And maybe more importantly, if there isn't a recovery, the contingency fee means that the lawyer doesn't get paid for their time, but they may still be entitled to be reimbursed for case expenses, which is something especially important in things like medical malpractice, where case expenses can be very high and the risk of loss is also very high. So that's something to keep in mind as well. The other thing I'll say about contingency fee cases, just because it is something that I have to explain pretty much every time I have one of these cases, is in addition to the lawyer, there may be other people that are entitled to get repaid out of a personal injury settlement or trial judgment or verdict or anything like that, and that we call those subrogated parties. So if you're involved in a car accident and your health insurance paid some of your medical bills, or maybe you have a hospital lien out there, they usually get repaid at least a percentage of their claim out of the settlement. So if you have a contingency fee, the lawyer's fee is based on, let's say, the first third or whatever it is, maybe minus case expenses, and then typically these other subrogated parties get paid. And your lawyer should be negotiating with them to try to minimize that, but there's going to be a payment there, and then sort of what's left then is what the clients get. And that's something that a lot of clients are surprised by when they hire a lawyer. They don't understand that these are things that all get taken out, but I like to emphasize that to people and re-emphasize it to people so that they're not surprised when the case gets to a resolution.
Could you briefly explain what a subrogated party is for those who may be listening and don't know?
Yeah, so subrogated party is any party that has paid for damages caused by someone else. So let's say you're driving your car and you're doing everything right, and a car comes and misses a stop sign and hits you, damages your vehicle, and injures you. There's going to be a potential for a number of subrogated parties. The first one might be your own auto insurance. So your own auto insurance will pay to have your car repaired, for example. Your own car insurance may have med pay. We did a video, the last one of the couple episodes ago, on insurance coverage, so that, if they do that, if they pay med pay, for example, they will be what we call a subrogated party. They may be entitled to reimbursement out of the settlement. Health insurance is probably the most common, or someone's on Medicare or Medicaid. There's a whole formula for them. Sometimes someone is involved in a car accident when they're on the job, and so there's actually a workers' compensation claim as well.
Oh, wow.
So workers' compensation may actually pay someone benefits because they were injured in the course of employment while driving their vehicle, and there'll be a settlement there they can actually be a subrogated party out of any auto accident case brought against the party that actually caused the crash. And there's a whole formula, at least in Wisconsin, on how they get repaid. So that's what we mean by subrogated parties.
I see. I had a question from a little earlier. So most of the injury cases that you work on, well, all of them, right, are on the contingency fee basis, correct?
Yes, basically,
Okay.
yep.
So the question that I have, and maybe for viewers too, is do you still track the hours you spend working on that case in the hourly model or in a different way, even though the payout is a third or dependent on recovery or not?
I do, and I don't think most lawyers do. I do for a couple of reasons. One, it's sort of for internal tracking purposes, and for, sometimes there may be multiple lawyers in my firm working on one case, and so we have to apportion that fee to the lawyer. So that is kind of one reason. Maybe the second and more important reason is lawyers are still required to charge something that's fair. Every lawyer is going to be subject to certain ethical rules promulgated by the state or states that they're licensed in. And most states have a rule that requires the lawyers to be fair and reasonably charge their clients. And so that might mean you couldn't charge a 90% contingency fee, unless it's like a complete flyer case. But, so just because the client agrees to something doesn't mean it's okay. You still have to be sort of fair about it. And sometimes, if a case resolves very, very quickly, you may be ethically required to reduce that fee because the amount of the fee is disproportionate to the actual amount of effort put in. And so recording time can be important for lawyers if there's ever any kind of question about the ethics of the fee.
I see.
It might be the other thing.
Good to know. Thank you.
Yep. So I think we've kind of covered things. I will say, just to kind of cover this a little in more detail, is what a trust account is. So most lawyers are going to have what are called trust accounts, and that is a special bank account where you keep client funds. And it is sort of, we call that sacrosanct, which means that the lawyer cannot commingle that. They cannot use funds from there to pay their rent or pay their employees or whatever. Those funds go into a trust account, and it's all of your clients' files are typically in one trust account, and that must always zero out, right? You must you can never go, you must never go in the negative in your trust account, or you have problems. And the trust account rules are dictated again by state, by the ethical rules, in terms of you have to have oversight to it. An attorney has to go through the statements. Someone in your office has to go through and reconcile them. If there's interest bearing on that account, most states require the interest generated on that to get paid to the state bar that you're in, and that those funds, they fund different programs that the state bar or the court system may operate. So that's kind of what trust accounts are. They're different from the
lawyer
lawyers.
or per firm? Is this for the firm?
Usually
No?
per law firm. So we
Okay.
have one trust account. I think we only have one. And so, yeah, all the lawyers in the firm will use it, and you have to register it with the state, and you can get audited and things like that. So, probably the most common issue that comes in trust accounts is if some lawyers, they get squeezed for money or whatever, or they have financial problems, may take money out of that trust account to pay expenses and then try to reimburse it later. You're not allowed to do that. That money has to stay in there, and has to, like I said, all the numbers have to zero out. But if you pay an advanced fee, for example, let's say you're doing it on an hourly model or even a flat fee model, that model may have to go into the trust account and then get, and then as the lawyer earns the fees, they can write a check from the trust account to their operating account to pay themselves, subject to notice to the client. And then if there is a personal injury settlement, let's say I settle a case for someone with an insurance company and they send a check, they will usually send that check to the lawyer in the lawyer's name. The lawyer will then deposit that into their trust account. and then it has to sit there for so many days so that it clears. And then from there, the lawyer will, let's say, pay the subrogated parties that we talked about, will then write a check out of that to themselves for their fees, and then issue a check to the client. Or, if you have like real estate sales, sometimes kind of like an escrow account, if you've ever bought or sold a house, it's similar to an escrow account. So you might hold funds as part of some business deal to be paid out, but it's this kind of that sacred account that lawyers and law firms have for their client funds. Now, you may not need a trust account if you don't get money in advance. If you just do the work, you send a bill to your client, they pay you, that actually doesn't have to go through the trust account. You can just pay yourself. It's more if you have money held for a client that you haven't yet earned yet, or isn't all yours.
I see.
Yep. So yeah, it's a good question.
Complicated though.
It is, and it can be, especially for people that have never hired an attorney. It's easy to, I deal with this all the time, so I just sort of think it's just common knowledge, but I understand that it's not. So, but yeah, I mean, I think those are the big things that people should understand when it comes to lawyers. It can be kind of intimidating and maybe even a little scary. Most lawyers, I think, are sincerely, good and will listen to you and not overcharge you. They shouldn't be overcharging you. Most lawyers, in my experience, quite honestly, are just a little overworked. And so the biggest challenges can be finding someone to actually, be able to talk to you or schedule a consult. That's a different problem. But yeah, I hope this helps people understand kind of how it works.
Yeah.
And if, people have other questions about it, certainly leave us a comment or drop us a message, go into the description, get a hold of us, and I'll be happy to clear it up in another video.
Yeah, and I hope we impart to the viewers and any future clients, hopefully, to not be scared, just to reach out. It's better to seek representation than not.
Yep. That's exactly correct.
All right. Thank you for listening. Thanks, Craig. Thanks for
you,
explaining
Leah.
all that.
Yep. Thanks, everyone, for watching. Let us know if you have any questions. Otherwise, until next time, everyone.
Yeah. See you later.
Have a good one.
Bye.